Okay, so welcome everybody to our very special session of our trade remedies training. First of all, I'd like to thank Escola Superior de Propaganda e Marketing, ESPM, in the name of the academic director, Rodrigo Sintra, who is here joining us. Without them, probably this wouldn't run so smoothly and everything wouldn't be so organized like it was. So it was a great partnership we made with between Women Inside Trade and ESPM. We are very grateful. And I also would like to acknowledge and thank Fernanda Cotizias, Marina Egidio, Carolina Sayeg, who are here with us. They worked a lot throughout the past 2 months to make all this happen. Veronica Prats, I'm not sure she's here already, but she's also a name I should mention. We don't do anything alone, so thank you everybody. Fernanda and Marina especially, they ran all the show throughout August and September. We had a very successful training, so thank you very much. So for this very special session, I'm very happy to introduce you to our speakers. They are world-renowned experts. They are very famous people who are here with us, who I'm sure have a lot to tell us about trade remedies and international trade as a whole, what's happening in Europe and in the US especially, and of course in the international arena. So I'm very pleased to introduce you to Bonnie Byers, Edwin Vermulst, Jessie Kreier, and Philippe Baere. I'm going to just read a short bio of the speakers so we can start this session properly. So Bonnie Byers, she joined King & Spalding in 2004 and is a member of the international trade practice in the firms in Washington, D.C. She's responsible for economic analysis of trade litigation and policy analysis of international trade and investment issues. She has 25 years of experience in the field of international trade. Edwin Vermulst has practiced international trade and EU law and policy since 1985 and is a founding partner of VBGB Advocaten. He is the editor-in-chief of the Journal of World Trade. He's a member of the faculty of the World Trade Institute in Bern and a member of the advisory board of the European Center for International Political Economy. Jessie Kreier is my colleague at American University. He's a former counselor and chief legal officer of the WTO Rules Division, where he left after 26 years of service in 2018. He was deeply involved in various WTO negotiations, including as secretary of the Doha Rounds negotiating group on rules. He's currently an adjunct professor of law at American University, Washington College of Law. And finally, Philippe Baere is a partner at Van Bell & Bellis and specializes in trade defense instruments. He has been involved in major EU anti-dumping, anti-circumvention, and anti-subsidy proceedings since 1990. He represents clients before the European Commission, the EU General Court, the EU Court of Justice, WTO panels, and the WTO appellate body. So we are very, very pleased to have you all joining us. And I'm expecting to have a very interactive audience. So we are inviting you already to pose your questions in the chat so we can make this interactive. We don't need to wait to the end of the session to make questions. So we are trying to make it really interesting for the speakers and for you all who are joining us this morning / afternoon in Europe. So to begin our conversation, I would like to ask each of our 4 speakers to comment on what are the highlights of what has happened in recent years with regards to dumping, subsidies, and safeguards, both in the US and in Europe. So maybe I'd like to start with you, Jessie, if you could comment on what was the impact of the suspension of the WTO appellate body activities on trade remedies disputes. Jessie, the floor is yours. You're muted. Just
Myself off mute. Okay, can you all hear me? Good.
yes.
All right. Well, that's a good question. It's been a bit of time now that we haven't had an appellate body mechanism. And clearly it has a potential in the trade remedy area to have a very large impact, not only with respect to the appeals of original panels, but obviously also with respect to the 21-5 process. So even if you have a panel outcome and you want an adjudication as far as implementation, you may not be able to get it. There is, of course, the MPIA available, this sort of alternative arbitration, alternative to the appeal process with the appellate body. But the MPIA does not include quite a few very, very significant actors when it comes to trade remedies, including, for example, the largest user of anti-dumping and of safeguards for that matter, which is India. Of course, it does include the United States, Argentina, Turkey, Russia, Indonesia. So these are all countries that have been very active, either or both, as users of trade remedies and also as complainants about trade remedy cases or actions taken by other countries. So for that matter, Japan and Korea are not part of the process. So the MPIA really is not going to cover this gap with respect to trade remedies. So the question is, first question perhaps, are parties going to be appealing these trade remedy cases into the void in order to prevent an outcome? So there have been 3 appeals into the void so far since the appellate body disappeared. 2 of them are trade remedy cases. Interestingly enough, the most recent, just the other day, was there could be a debate about whether this is an appeal into the void or not, but the Europeans have appealed a decision with respect to their cost adjustment methodologies, which of course is really probably the biggest issue in trade remedies today. This was a case brought by Russia. So the Europeans have appealed that. They have encouraged the Russians to join the MPIA. It doesn't look like the Russians are going to, based upon what they're saying in the dispute settlement process. So what's really the biggest legal issue in the WTO on anti-dumping today, for the moment, seems to be in a sort of a state of abeyance in terms of adjudication. There has been a big drop-off in the number of disputes brought in the WTO generally, and that's also a drop-off in terms of trade remedy cases being challenged. But we are still seeing some. So Turkey has just asked for a panel against the EU with respect to safeguard measures, and Peru has just asked for, people there probably know this better than I, Peru has just asked for a panel, it's just sought consultations regarding a Brazilian measure. You know, a couple of questions. How is the absence of an appeals mechanism going to affect people's behavior? And we can think of that a couple of different ways. One question is, what will panels be doing in the trade remedies area now that, for the moment, there's no appellate body? Will they change their behavior? Will panels move in a different direction in some areas potentially than they have while the appellate body was there? It is interesting to note that this, in the area of zeroing already, there's been one panel which is not proceeding because there's no appellate body, which is the United States differential pricing methodology, which is all about targeted zeroing. And that panel, basically the panel said, we disagree with the appellate body and we're coming up with a different approach in the zeroing area. And that's happened many times before. And the appellate body has always said, sorry, and reversed them. But since there's no appellate body now, we'll see whether panels start behaving differently in some of these areas. The other question, of course, is whether members using trade remedies are going to be willing to take more risks, knowing that ultimately there's no binding dispute settlement system anymore when they act. And there we'll just have to see. Finally, I guess I'd just say sort of this reversion in a certain respect to pre-WTO with respect to dispute settlement, I think puts a lot more pressure on some of the other institutions in the WTO, like the committees, in terms of other processes for trying to, for member interaction, the application of peer pressure, et cetera. So this could conceivably result in a more active and meaningful set of exchanges in the non-dispute settlement fora in the House. So that's my take.
Excellent, excellent. And I guess we are going to go back to this subject later in this session, because I know a lot of people have interest in listening to what you have to say about WTO crisis and trade remedies and etc. So thank you so much for setting up the stage. And Bonnie, I would like to ask you, especially with regard to injury determination, was there an impact of COVID-19, of the pandemic, in injury determinations in the US?
Yeah, thanks very much, and hello everybody. It's nice to see you all, and it's great to be here. Thank you for inviting me. I want to just step back and talk a little bit more generally about the impact of COVID on AD/CVD operations more generally. You know, it's really affected the way that the Commerce Department does its dumping and subsidy investigations and reviews, as well as the injury determinations made by the International Trade Commission. One of the biggest changes, of course, is the lack of in-person hearings. Both the ITC and the Commerce Department hold hearings as part of their process during investigations and reviews and sunset reviews, and they're not doing those in person anymore. So it's really changed the complexion of the way these investigations get handled. They are doing via Zoom conferences, but you know, it's not as good as having everybody in the room, and so I think that's been one big impact. One of the positive changes that I've seen is that the U.S. has finally come into the 21st century, and all filings are now done completely electronically. I mean, we were still in the dark ages before COVID, serving paper copies on other parties and having to file paper copies with the agencies, and now everything is done electronically. And my hope is that once COVID is over, they don't revert back to the old system. I think the biggest change that I've seen since the advent of COVID is the lack of on-the-spot verifications. The U.S. just hasn't been doing them since March. And that can affect the proceedings in a number of ways. From the respondent's standpoint, it could either be a good thing or a bad thing. I'm working on a case right now for a Brazilian producer. It's a countervailing duty case on aluminum from Brazil. And I think it's highly unlikely that the U.S. is going to do an on-the-spot verification in São Paulo, but whether they do something in lieu of that, like a Zoom verification, I don't know. They haven't been doing that. They've just been canceling verification outright. So, you know, that affects things in a number of different ways. One, if you are the respondent, Commerce isn't going to collect any additional data at verification. Normally that's a time for respondents to clarify the facts of the case and to review the Commerce methodology. And that's simply not going to happen. The record is the record, and there won't be any additional information gathering that normally occurs at verification. If you're a petitioner, I think there's been some complaints among the petitioners bar in the United States that the lack of verification is now encouraging respondents to not be fully forthcoming during the investigation process of questionnaires and questionnaire responses, knowing that they're not going to be subjected to verification. So it's had some real effect, I think, on the quality of the investigations and the potential outcome of those investigations. You asked the question about what does the impact of COVID have on ITC injury determinations. And it's still a little bit early days yet to know exactly how that's going to affect that, their analysis in terms of injury and threat of injury. What we've seen is that, and as I think you know probably from your training over the last month as part of this process with the ESPM, is that the ITC is required to ensure that it's not attributing injury from other causes to the subject import. So it really needs to sort of separate and distinguish the impact of COVID on what's going on with respect to the domestic industry. I think everyone's assumption is that COVID is going to have a negative impact on the domestic industry, although the one case where this came up, and that relates to PET film from Korea and Oman, there was actually a beneficial effect for the domestic industry because that type of plastic was being used to produce the kind of masks. So their condition actually improved as a result of the coronavirus. Notwithstanding that, the ITC still went affirmative in that case. And there was another case related to glass bottles in which the domestic industry argued that COVID should be considered as part of the Commission's threat analysis because the consumption of products that come in glass bottles is diminished. And the ITC actually looked into that and said, well, people aren't going to restaurants. When they go to restaurants and bars, they're mostly drinking beer on tap. And now everyone's drinking beer at home. And so therefore, it's likely that the consumption of beer in bottles is going to go up. And they actually made a negative determination. But as more and more decisions come out over the next couple of months where the period of investigation includes this COVID era, I think we're going to see a lot more arguments. The domestic industry will argue that the epidemic actually makes the domestic industry more vulnerable to injury from imports. And of course, if you're representing respondents, you're going to make the argument that everything is because of COVID and not because of subject imports. So more on that later, but it's a very interesting topic.
Thank you so much, Bonnie. Very interesting. So I would like to suggest that we fly to Europe now. And I would like to ask Edwin and Philippe, what would be the highlights of what has happened in Europe recently with regard to trade remedies in the region in general? So, and then we go more to the specifics in a third round of questions. So maybe who'd like to begin?
I will start if that's okay with Edwin.
Sure.
Thank you, Renata, for having me on the panel. A very interesting group of people, I must say. As what are the highlights? Obviously, it's difficult to identify a specific highlight because for each lawyer, his own cases are the highlights of the year. But I would like to take a step back from trade defense, the instrument first. Because obviously trade defense doesn't operate in a vacuum. To use a WTO term, it's not in clinical isolation from the rest of the trade policies that we have. And if you look at what has happened to it, EU trade policy and global policy, trade policy developments in general, is that we have seen that there has been a step back from the idea that free trade is good in itself. We have come to a situation whereby the notion of free trade as a good in itself has been questioned, and that we more and more hear sounds about the need to have free trade to be a fresh look at it and to place it in the context of national security, economic development, environment, etc. And what we have seen in Europe is that the EU's trade policy has become much more assertive and protectionist. If I step back to 2016, the previous Commission, Juncker, Mrs. Malmström, there the title for the trade policy program was Trade for All. And there in that program, really the benefits of free trade were being stressed. Under the von der Leyen Commission, trade policy's motto has changed from Trade for All to Open Strategic Autonomy, which obviously sounds a lot less sexy than Trade for All. But open strategic autonomy stresses two things. First, strategic. It points to a kind of more geopolitical use of trade instruments and trade policy by the EU. And that is maybe also related to the fact that China has now been identified explicitly by the European Union as a kind of systemic rival. The word autonomy in open strategic autonomy, in my view, refers also to the need of protecting better the supply chains, and have been influenced what has happened by the COVID-19, where more and more the European Union has been stressing the need for reshoring essential production activities and the creation of national champions. So this kind of change in the EU trade policy has certainly had its effect on the trade defense instruments. And what we have seen is that clearly there's an encouragement by the Commission for a more robust use, a more assertive use of trade defense instruments. And unfortunately, I must say that this has been accompanied, in my view, with less concern about the WTO consistency of some of its measures. And this will, as Jesse said, this will maybe become worse now due to the absence of the appellate body and a kind of multilateral control. But the main example, and again, that's what Jesse said, the main point where we have really a discussion, a possible discussion, is the issue of cost adjustments, and more general is how do you determine normal value for non-market economies like China. The EU has adopted, following the expiry of the provisions in the China's protocol of accession, has adopted a specific methodology which would replace the former non-market economy methodology, which was used specifically against China, by a new methodology which addresses so-called significant distortions in the market of the exporting countries. So this distorted economy approach is basically a replacement of the previous non-market economy system. But differently, and obviously intentionally, this new distorted economy methodology no longer targets China explicitly. It's erga omnes. In theory, it could be applied against each and every country where significant distortions on the domestic market exist. If the Commission finds that there are significant distortions, we go back to some kind of analog country methodology, which here now is replaced by a system where prices and costs can be used, can be based on out of country prices and costs. It's no longer a pure analog country methodology as under the non-market economy system, but basically it leads to a situation whereby first the Commission has to identify that there are significant distortions existing in the domestic market, and if that is found, then they will go to a system whereby they replace the prices and costs of the Chinese domestic, in this, well, most of the cases, Chinese producer. Now, the legality of this approach is obviously very, very doubtful. The notion of significant distortions in the domestic market is something that obviously is not mentioned in the anti-dumping agreement. It is very similar to a system whereby cost adjustments are being made to normal value, where the importing country finds that the costs in the exporting country are not normal or not reasonable, and then being replaced by costs from international prices or cost or another out-of-country benchmark. And we all know that the appellate body in the biodiesel cases, Argentina, Indonesia, the recent UIN dispute, has every time ruled that you cannot just replace costs in the exporting country because you consider that these costs are not reasonable or are distorted. Now, the EU obviously has ignored this kind of findings, and is probably aware that this approach is not really WTO consistent. But what we see is that the EU has been applying this provision only against China, even though officially it is a methodology which could be applied to any country at all. They have also drafted a working paper by the Commission which identifies for the use of European complainants which distortions exist in China, so that the complainants can already invoke that. They have not made such a working paper for any other exporting country in the world, even though initially they had mentioned that Russia would be the subject of such a paper in the future. So what we see really is a de facto replacement of the non-market economy system applied against China by a distorted economy approach, which is probably WTO illegal, but as long as it's applied against China, it is unlikely to be tested in the WTO. To finish, there is also an introduction of a significant distortion concept in the European injury determination. So where we, in Europe, we work with a so-called lesser duty rule. We calculate a dumping margin and an injury margin. If the injury margin is lower, then only the lesser duty is applied. There has been a provision introduced now, separate from this normal value provision, whereby that if the Commission identifies significant raw material distortions, they may decide not to apply the lesser duty rule and to impose the anti-dumping duty at the level of the full level of the dumping margin. So this is, I think, one significant development in the last 2-3 years in the European trade defense instruments.
Excellent, excellent. Thank you. Edwin?
Thank you very much, Renata. I'm going to discuss something else. I'm moving to the subsidies area, and more specifically the issue of transnational subsidies. And this occurs if, for example, if more countries than one are subject to investigation, and the subsidy is given by a government in one country to producers in another country. The first case where this came up in the EU was a case involving glass fiber fabrics from China and Egypt. And in that case, the Chinese producers had also set up factories in Egypt. And according to the complainants in that case, they received 3 types of subsidies. First of all, the Chinese companies located in Egypt in the Suez Economic Development Zone, so a certain area of Egypt, they received loans directly from Chinese banks, from the China Development Bank and the Chinese Exim Bank. So these were direct loans given by Chinese banks to the Chinese producers located in Egypt. The second type of loan that was alleged to confer a subsidy were loans received by the parent company, by the mother company in China, but which in the view of the complainants and later the Commission indirectly benefited the producers, the subsidiary companies in Egypt. And then the third type of alleged subsidy was the financing by the mother company of the capital investment of the daughter companies in Egypt. So there were 3 kinds of subsidies, so to speak, which were the subject of this investigation. And before I go in more detail, I will make a few general comments. And the first comment is that this is no longer an isolated case. This is quickly becoming a systemic practice, a bit the same as Philippe said before, targeting China and more specifically the Chinese Belt and Road Initiative, which is a hot political issue in Europe because the Chinese with the Belt and Road Initiative are making inroads all over Eastern and Central Europe, and also in many other countries like Egypt. So since this first case was decided, there have been two other cases, filament glass fibers, again from Egypt, and a third case involving stainless steel hot rolled, this time involving China and Indonesia. So in all three cases, you had the mother company, so to speak, in China, and you had daughter companies, 2 times in Egypt and 1 time in Indonesia. And the same type of financing is alleged to confer these, what we call, or what we can call, transnational subsidies. Now, my final general point is that the EU claims that they themselves are the main provider of foreign direct investment. They claim they are the biggest provider of foreign direct investment in the world. So if that is true, then of course there is a risk sooner or later of mirror action by third countries against overseas production facilities of EU producers. So I think this new practice of the EU will come back to haunt it, to hold back its own foreign direct investment, but we will see, of course, whether that happens. Now, how did the EU legally justify, because the EU accepted the complainants' allegations and they treated these 3 types of subsidies as subsidies, but how did they do that legally? First of all, they decided basically, as you know, there's the 3 criteria: financial contribution, benefit, specificity, unless we are talking about prohibited subsidies. So in terms of the financial contribution, the legal justification of the Commission was that Egypt had acknowledged and adopted the financing support from the Chinese government as its own. So the key term is that Egypt had acknowledged and adopted the financing support from the Chinese government as its own through political declarations, and because it was jointly cooperating with China, that special economic zone in the Suez, or near the Suez Canal. And the legal basis for this was Article 11 of the International Law Commission's articles on state responsibility. So the EU did not refer so much to the SCM agreement, but instead to get over this barrier that the subsidies were given by one country to producers in another country. They used these Article 11 of the International Law Commission's articles on state responsibility. In terms of the benefit, they used the same legal justification, but on the other hand, they used the methodology, which is basically out-of-country benchmark, a little bit similar to what Philippe has explained in the dumping context. You don't use the, if there's a subsidy, you use an out-of-country benchmark to value the subsidy, because in the view of the Commission in China, everything is subsidized, so you have to go somewhere else to get a market price of the raw material or of the service. So they use the methodology that they normally use in Chinese cases for the quantification of the subsidy and for the calculation of the benefit of the subsidies received by the Egyptian producers through these financing mechanisms from China. In terms of specificity, they considered that the Suez Canal zone, this special zone, was an overseas investment territory of China, but it was limited to the Suez Canal area, and therefore it was a regionally specific subsidy. Now, we have, I and several of my colleagues, we have made some arguments. I think Jesse doesn't agree with it because we had a webinar on this last week too. But in our view, first of all, this is not a subsidy within the meaning of Article 1 of the SCM agreement, because in the SCM agreement, first of all, the term government has been interpreted by the appellate body as being both having a narrow definition, the government, but also the government in a collective sense. And in the collective sense, it also includes public bodies or private bodies entrusted or directed with government functions. So that's the first point. And secondly, if you look at Article 1.1 right in the beginning, it mentions a member. But if you look further down in Article 1.1 A.1.4, you see that the term governments is used. So the plural term is used. So in the same article, you have generally the singular term, member, but then in the very last article, or in Article 11A14, you have the plural term governments. So from our perspective, if the SCM drafters had intended to include these kind of transnational subsidies within the meaning of Article 1, they would have used the plural term members in Article 1.1 in the beginning. Secondly, there are various different articles in the SCM agreement. For example, Article 2.1 dealing with specificity, Article 14A dealing with benefit, Article 25.2 dealing with the notification requirement, and also there's a section 15B in the Chinese Protocol of Accession to the WTO, which each time refer to territories of members or territories within the jurisdiction of the granting authority. So if you put it all together, in our view, it is clear that only subsidies are covered that are given by a government to producers within its territory. Finally, as far as the invocation by the European Commission of Article 11 of the ILC articles is concerned, in our view, these articles, or this article, is not relevant. First of all, it's not a rule of international law, in our view. Secondly, the subject matter is not the same. The SCM and Article 11 deal with different subject matters. And third, at least in our view, the SCM agreement provisions are clear and unambiguous. And as long as that is the case, you don't have to resort, or you should not resort to outside sources of interpretation. So I think I'll leave it at that for the moment, Renata. We'll come back to this later on, maybe.
Thank you very much. I just realized we have made a mistake because we needed 3 hours at least and not 1.5 hours with you all. So I regret already, but okay, let's go to the, now we organized 2 rounds of questions now that are more specific. So the first round, I would like to ask to Bonnie and Jesse issues from the US perspective, and then we go back to Edwin and Philippe with the EU perspective. So Bonnie and Jesse, during the current US administration, we are experiencing an intense use of unilateral measures with emphasis to Section 232 and 301. I would like to ask you to provide an overview of what has been happening with regard to those measures and with regard to trade measures in general in the US, so we can be more specific now, and what are the possible inconsistencies with WTO rules. So maybe I can go with you first, Jesse.
Sure. Okay. So I'm going to talk about 2 things. I'm going to talk about Section 232, and I'm also going to talk a little bit about currency undervaluation. In fact, maybe I'll talk a bit more about currency undervaluation than I will 232, because 232 is probably very familiar to people, especially to the extent the audience here is Brazilian, for example. You're very aware of some of these 232 measures. There have been more of them, or at least more investigations on a wider range of products than just steel and aluminum. Of course, there's the autos 232, which is hanging out there in a state of limbo now. But there's been a case on uranium, titanium sponge, mobile cranes, of all things, vanadium, and I'm not even sure what vanadium is, but I guess it may have some defense applications, and transformer laminations. So in addition to the really high-profile 232 cases that we all have heard about, steel, aluminum, autos, there are a bunch of others that are also pending and quite recent. There's mobile cranes, vanadium, transformers. Those were just started this summer, and we don't have outcomes yet. So this is an interesting development, obviously, that the US is using a national security justification instead of using, or in addition to using traditional trade remedy mechanisms. Now, there's been, not surprisingly, a lot of litigation in the United States about these measures. And I'll just mention that there have been a couple of outcomes that are significant. One of them has to do with the constitutionality of the congressional authorization to the president to take these Section 232 measures. And there was a constitutional challenge, basically a separation of powers issue, an unconstitutional delegation of power that wasn't sufficiently circumscribed, the complainant said, allowing the president too much power, basically giving the president the power to do things that Congress, which has the power to regulate foreign trade, is supposed to do. That complaint failed. So the Court of Appeals for the Federal Circuit said there's enough guidance in the legislation and the delegation is proper. So in that respect, the courts have so far upheld presidential power with respect to Section 232. Another set of issues has to do with deadlines for action. And here the courts have been more willing to entertain complainants' arguments. So what's happened is you've had these national security measures imposed, and then the Trump administration has been periodically changing them, lowering quota amounts, et cetera, doing, changing the scope of application of these measures in various ways. Some people would say doing that for negotiating purposes, but that's a question of interpretation, perhaps. In any event, we did have the Court of International Trade, which is the first level court of review in the United States, find that changes to the scope of measures with respect to Turkey in the steel context were not allowed by Section 232 because they came outside there's a 90-day window for the president to take action after he gets a report from the Commerce Department. And those actions to modify measures were outside of that 90-day period. So this has really potential implications in terms of the sort of continuing use of Section 232, changing the measures, adjusting the measures, perhaps reimposing the measures on countries that have been excluded, et cetera. There's also in that Court of International Trade decision a ruling with respect to equal protection under the Constitution, which could end up having an impact in terms of the ability to sort of pick and choose how these measures are applied to different countries. So there has been a lot of litigation. I'm sure there's a lot more litigation, and we're going to see many, many more cases coming out. Nevertheless, as I say, the president has continued to engage in adjustments to these measures with respect to Canada, Mexico, Brazil, so we'll see how that all proceeds. Meanwhile, of course, there are WTO challenges to these measures. Since we don't have an appellate body, it's not clear where those challenges would go. On the other hand, since many countries have chosen to treat these Section 232 national security measures as safeguards, they've decided that they can unilaterally respond by invoking the safeguard provisions that allow you to respond to safeguard measures that are not consistent with the WTO agreement or that are not based upon an absolute increase in imports. So in fact, the European Union, for example, doesn't really need to wait for the dispute settlement system to retaliate. It's already done so. And of course, those retaliatory measures are also before WTO dispute settlement and will also, be stuck because there's no dispute settlement mechanism. So it's sort of ironic that we're in this sort of in the safeguards context. We have this authorization of unilateral retaliation that we don't really have anywhere else in the system. So it's tit and tat going on here. Meanwhile, just sort of as a curious sidebar, other countries, of course, have imposed themselves safeguards, pointing to the US safeguards on steel in particular and saying, that's an unforeseen development and all that steel is being diverted into our market. And interestingly enough, Turkey has just asked asked for a panel with respect to European safeguards on steel. So all these things are interrelated, and it's interesting to watch how they're evolving. There's so much happening in this area, and I'm sure Bonnie and many of you know a lot more about it than I do, but it is a very interesting area evolving. Oh, I should also say, of course, that we've had a series of WTO disputes about what national security means and how the exception can be invoked. One of them has been appealed into the void. And the other one is pre-appealed into the void. So both of them we won't get outcomes. But what we do know in terms of what panels seem to think so far is that the idea that that a national security exception is completely unreviewable is not right, although the extent of the review is not the same as you might have for other types of measures. So it's all very interesting to watch. The other thing that I'd like to talk about a little bit is a countervail issue, and that is currency undervaluation as a countervailable subsidy. And here, the US has new regulations that were put in place in February 2020, which are quite significant. Now, there has been legislation in Congress about currency undervaluation as a subsidy as far back as I can remember, and I'm a really old guy. So Congress has been trying to do this for years and years and years and years, and periodically when I was at the WTO, every few years, there'd be a new piece of legislation, and there'd be all kinds of questions. Well, can they do this? Can they do this? Is this WTO consistent, et cetera? It never happened. And finally, this administration has decided that they don't need a change in US law to do this. They can simply do it by implementing regulations, and they have. So what you really have is simply some amendments to the US regulations that address a couple of issues. They address the question of benefit, and they address the question of specificity in the context of currency undervaluation. What they really do is say currency undervaluation is, or at least can be, a countervailable subsidy. Now, what do the regulations say? The first thing they say is, in order to countervail undervaluation, you first need a determination that a currency is undervalued, of course. And in making that determination, the Department of Commerce is required to consult with the US Treasury, which of course traditionally is the agency that would be responsible for dealing with issues about things like currency undervaluation. But the requirement to consult is not a requirement for the Treasury Department to make the decision. This is going to be a decision that's going to be made by the Department of Commerce, not by the Treasury. And it'll be interesting to see what the nature of the Treasury inputs are and how much the Department of Commerce pays attention. So what is currency undervaluation and how do you value it as a subsidy? Basically what the regulations say is that there is undervaluation if the existing exchange rate doesn't result in a balance, sort of an external exchange balance in the medium term. So in other words, if you have a currency that's undervalued and as a result you have surpluses over the medium term, if the exchange rate is not one that's going to generate a balance in your exchanges over time, over the medium term, then it's undervalued. And there's a lot more to this publicly, of course, a lot more to this technically than I'm describing, but that's basically the idea. And then the amount of the benefit is the difference between exchanging foreign currencies for domestic currency. If you did have this sort of equilibrium exchange rate, how much would you get? And as opposed to what you're now getting based upon the current exchange rate. An interesting area here that's not specifically addressed by the regulations is, so where's the government action? What is the financial contribution by a government? Which is, of course, as I think it was Edwin pointed out, is an element under the WTO agreement. And Congress has basically said, we'll deal with that in the specific cases. So we don't know whether this is going to be a situation where it's only in context where there are state-owned banks, perhaps, that are responsible for handling currency exchange, or whether Commerce is going to try and use ideas like entrustment and direction of private actors, you know, so that in fact it's not the government who's buying and selling the exchange, the currency, but it's the government sort of setting up a system where currency is exchanged by private actors, but because of the government role, there's a financial contribution that's attributable to the government. So that will be really interesting to see, but it's quite curious, they haven't said much about it. In fact, they specifically said, you know, there were questions about it during the comment process, and they've said, well, we'll deal with that in due course. Another interesting question is, how is this specific? So basically, you're talking about an exporter who gets more money in his currency when he exports. How is that specific, since we're assuming we're not talking about a situation of multiple exchange rates, but a single undervalued currency? And Commerce has said this is specific. The group of enterprises is enterprises that buy or sell goods internationally. So this is their conception of specificity, which is an interesting one. I sort of wondered why they didn't go for export specificity on the basis that it was an export subsidy, but they didn't. So we're going to have to wait and see how this all unfolds. There is a first case ongoing, which involves tires from Vietnam, and the outcome, there was supposed to be a preliminary determination, but now they've delayed the determination until the 30th of October. So we'll have a better idea as to perhaps as to what's going to happen with respect to currency undervaluation when we see that first preliminary determination. WTO consistency, I think my conversation here has already identified some of the issues that are going to present themselves. Where's the financial contribution? Is there really specificity in this situation? I've also heard people talking about, you know, if you almost making sort of a zeroing argument where, I mean, you may have to import inputs in order to make your exports. And so you have sort of, you know, negative subsidy because of the undervaluation, and do you have to offset the negative against the positive subsidy? So there are going to be a whole lot of issues, but it is I think, a really major development. Finally, I'll just say, thinking back to what Philippe said about his talk about distortions, obviously these issues about input prices, distortions, people are coming up with methodologies, particular market situations, et cetera, everywhere, including the United States and most other members as well, who have trade remedy systems. So that is obviously a huge issue in the US as well.
Great. Bonnie, your take?
Yeah, thank you, Josie. I thought that was a great overview of both 232 and where we are on currency. I just think it's so ironic that the first case that Commerce is considering regarding currency misalignment doesn't even involve China. It's a Vietnam case. So, Jesse, I also want you to know that vanadium is a very important product. It's used as an alloying material for both aluminum and steel that are used in a lot of defense applications. So just so you know, it's a very valid case. Obviously, I'm working on it. So I want to give a brief overview. I'm not going to go down in the weeds too much on some regulations, some draft regulations that Commerce issued back in August. The ostensible reason for issuing the draft regulations was to sort of streamline some of the procedures related to a couple of the review processes that I'm going to talk about here. But I just want to go back to what Philippe said, because I think this deserves some bigger context, which is, you know, the Trump administration from day one has made enforcement of the trade laws a real priority. you know, one man's protectionism is another man's enforcement. So, but for this administration, they have put a very high priority on the enforcement of the trade laws, and in using trade laws like Section 301 and Section 232 that were basically moribund for over a decade or more, to try to get at various aspects of unfair trade. I think a lot, and Jesse just sort of alluded to this, but I think a lot of the things that we see going on in Europe and the EU is to try to formulate the trade laws in a way to really deal with the China problem. And I know we're going to talk more about China at the end, but I think a lot of these sort of contortions you see both the Commission and the administrating authorities in the US going through right now are how can we mold these trade laws in a way that really gets at a very different economic system, which is what we're dealing with when we're talking about a country like China. So the US, the Department of Commerce back in August issued draft regulations dealing with a number of areas. And, you know, I think there's been a large outcry. Actually, comments on the draft regulations were due yesterday. So if anybody's interested, they can go on regulations.gov to see what the various parties are saying about these regulations. But I think the general perception is that the regulations, the draft regulations, make it easier for the Department of Commerce to identify situations where there's evasion of duty orders. And the first relates to new shipper reviews. Under US law, if you're a company that had not been producing and shipping during the original investigation, you're entitled to ask for your own review. So that instead of having to pay the all others rate when you export to the United States, you can try to get your own rate. The Commerce Department has just really, for a long time, hated this provision. It creates a lot of work. They have a hard time determining whether the imports from a particular exporter are actually bona fide exports. So, for example, you might have a situation where an exporter is really the reincarnation of somebody else that's got a really high rate, and they just set up a new company. They have one shipment at a very high price that forms the basis of their dumping calculation, and therefore they can get either a zero rate or a very low rate and begin shipping that way. So what the Commerce Department has done through these draft regulations is to try to tighten up the criteria for determining what's a valid bona fide shipment that can form the basis of a new shipper review. And in doing so, they've made the requirements for providing information a lot more stringent and detailed, probably with the desire to discourage these kinds of requests. One of the things that they've done is given themselves 60 days before they even initiate a new shipper review. So, you know, it's not like you can request a review and get a pretty speedy determination. Commerce won't even decide whether to initiate unless until after 60 days. So the other thing that Commerce has done is to change the requirements for new shippers from posting either a bond or a security to requiring cash deposits at the all others rate. So again, making it very onerous for new shipper reviews. And then, as I said, they've also tightened their requirements for demonstrating that something is actually a bona fide shipment. And one of the things that they've done, and there's been a huge outcry about this, is they've said, if the foreign exporter and the importer in the United States are related parties, you effectively can't ask for a new shipper review. You can only get a new shipper review if the foreign exporter is selling to an unrelated party in the United States. The other changes relate to scope inquiries and circumvention inquiries. As you know, in U.S. Anti-dumping and countervailing duty practice, the scope is established in the investigation phase, but very often what happens is that questions come up subsequently related to whether something is either inside or outside the scope. So Commerce does scope investigations to make those sort of clarifications. And what they've done is they've streamlined their procedures for those scope inquiries. One thing that they have done is they've provided themselves the ability to self-initiate a scope investigation. They have created or will be creating an actual template for providing the information necessary to get a scope inquiry initiated. And that standardized application supposedly is going to make it easier on them to administer these kinds of inquiries. And the other thing that they've done, which is a big improvement in my view, is to establish some firm deadlines for themselves, because very often the scope inquiries are made and then they just go off into the ether, and there's no real deadline for making determinations. Similarly, with circumvention inquiries, these are generally brought by petitioners who have seen the benefit of an order eroded because either things are being assembled in third countries and shipped into the United States, or final finishing is done in the United States of inputs that make the product subject to the scope. So again, here Commerce has tightened the deadlines on that, really to the benefit of petitioners. Instead of initiating circumvention inquiries within 45 days, they now are going to do them within 20 days. They've also, for the first time, established a deadline for a preliminary determination. So there never has been a firm deadline for that. They have to make a firm deadline, a preliminary determination now within 150 days. They've also broadened the scope of circumvention in a way that benefits domestic producers, which is instead of finding circumvention just by a particular company, they're going to make the decisions on a countrywide basis. So if a particular exporter is found to be circumventing the order, Commerce will make whatever changes they make under the circumvention provisions applicable to all producers in that country. So that's a fairly big change as well. And then finally,
dear all, please, yeah.
muted.
Yeah, great.
The other thing that they've done is they've allowed, they've made a provision where they can suspend the liquidation of entries sooner in the circumvention process, so that they'll get at circumventing products going back in time rather than going forward in time from the preliminary determination. That suspension now can apply going forward from the date of initiation. So really big changes potentially. The comment period, as I said, ended yesterday. There is a provision now. They have not provided any time for rebuttal comments, but there was such an outcry that now they have provided for that. And those are due 2 weeks from now. So it will be very interesting to see what comments are made on these, what Commerce eventually does. Clearly, this is a Trump administration effort to strengthen the trade laws, especially to strengthen enforcement and, to guard against evasion of the trade laws. And so they really, if they're going to do this, they need to review the comments and get the final rule out during this administration. Of course, that won't be the case if the president is reelected in November. They'll have more time to do that. But I think the timing of this is such that their desire is to get these things in place before the end of any Trump administration, if that's what occurs. I also had wanted to just touch really briefly on what's going on at Commerce. I know that there are a lot of trade law administrators on this conference call, and a number of people from DECOM. So, you know, I think it's worth mentioning that we are seeing a record high number of cases at the Commerce Department. Just in the last fiscal year, there have been 104 cases initiated, both anti-dumping and countervailing duties. That's almost double from last year. And yet the number of employees has not risen really at all. They have asked for more money to do more hiring. But that combined with you know, the need for everybody who is working on these trade remedy cases to be working from home, it's made it just an impossible situation. So Commerce has tried to think of ways to lessen its own burden. And one of the things that they've done is to extend the deadlines for administrative reviews. They've tolled those deadlines. Usually tolling only occurs when you have natural disasters, you know, hurricanes, huge snowstorms, when the government shuts down. But they are pointing now to the coronavirus as a reason to toll the deadlines. They did it once for 50 days, and when that expired, they renewed it for another 65 days. So they're giving themselves more time to work on these trade remedy cases. As I said, they've also canceled verifications. In some instances, they're not looking at new subsidy allegations. So they've tried to reduce the amount of the burden, but really what they're doing is kicking the can down the road, because this is all work that's going to have to be done eventually. So without more resources, it's going to be very difficult for them to do their job. And I think I'll just end it there.
Excellent. Thank you very much, Bonnie and Jesse. So I'd like to shift now to the EU perspective again. So Edwin and Philippe, as you mentioned in the beginning of your session, recent years have seen several interesting developments and changes in the EU trade remedies law and practice. So I'd like to ask you both to comment a little bit on the several changes, a little bit more. You have already outlined several of the changes in your first contribution to this session. But I'd like to ask you to go deeper in this and including comments on the publication of the white paper on foreign subsidies. And also I'd like to add one question that is, I'm sure the Brazilian audience would very much appreciate, that you may add some comments on public interest perspective, what has been happening in the EU. This is a hot topic in Brazil for the past months. So I'd like also to add this question and ask you to kindly answer it. So maybe Philippe, you would like to go first?
Well, I went first during the first part, so if Edwin wants to take over now, please feel free.
Okay, I'll take over then, Philippe.
Okay.
But I'll try to leave time for you because we don't have that much time left, I think. Let me maybe then start in view of the interest of the Brazilian audience with the public interest, or the union interest as we call it over here. Very briefly, the EU normally holds that the union interest is the interest of the EU to have domestic producers of the product that made a complaint. So the union interest is normally ruled to be the interest of the EU to have a domestic industry of the product concerned, but not always. So there have been some cases, especially I would say high profile cases, where union interest has played a bigger role. And that would be typically, for example, if it is a consumer product like shoes. We had a big case on shoes from Vietnam and China a few years ago. Or if it is a case where there is a group of users who are very active. And when I speak of users in this context, normally, of course, it means producers of downstream products of the item under investigation. So in those kind of cases where users or consumers are concerned and are vocal, are active, the union interest may play a bigger role. And in that context, I think you can compare it a bit to a Swiss Army knife. It can play many different roles in an investigation. First of all, if there is a lot of participation from users or from consumers, then in some cases there is a special questionnaire for these users or even for end users of the product, which then has to be completed. And then in terms of the result, for example, in some cases, it has been decided that one form of duty is more appropriate than another form of duty. Normally in the EU, an anti-dumping duty is an ad valorem duty, a percentage duty, 20%, 30%, 2%, 15%. But in some cases, it has been decided that because of union interest, for example, a variable duty might be more appropriate. And this happened in the case involving grain-oriented electric sheets of a few years ago. So on union interest grounds, it was decided not to impose an ad valorem duty, but to instead impose a variable duty. Second, it can be decided that it is in the union interest to exclude certain products from the scope of the proceeding, even though there is evidence of dumping and injury of those products. And an example of that was the footwear case that I mentioned before, where in the provisional stage, the Commission decided to exclude children's shoes, shoes for children. And the reason for that is that, as you may know, those of you who have children need many shoes, many pairs of shoes, right? Because they grow, the feet grow quickly. So maybe in 1 year, they need 2, sometimes 3 different pairs. So of course, families with big children, with many children, are disadvantaged by an anti-dumping duty on footwear because they have to pay proportionately more. So in this footwear case, at the provisional stage, it was decided to exclude children's shoes because of union interest reasons. But at the end, in the final result, it was turned around and they were included again. So it was of short help, but it helped a little bit. Third, it can be used as a way to limit the duration of anti-dumping measures. Normally, anti-dumping measures last for 5 years, but in some cases on union interest grounds, they have lasted only for 2 years. And then there was an interim review, and sometimes they were stopped after 2 years. Sometimes they were extended for another 2 years. But anyway, the duration has been limited on union interest grounds in a number of cases too. And then finally, perhaps, it has been used as an independent reason to close a case, even though there was dumping and injury. So even though there was dumping and injury, still it was decided to close the case. And in this context, perhaps we have to distinguish between the closure of a case because of pressure from member states, or because the Commission itself decides to terminate the case on union interest grounds. In some cases, but those are relatively rare, the Commission itself decides to close a case and then they propose that to the member states, and then the member states will normally agree with the Commission. But especially in the past, the member states had a relatively big role because a simple majority of member states could block a Commission proposal to impose measures. So at the time when we had 28 member states, the UK still being there, if you had 15 member states against, the EU could not go ahead. And so sometimes these 15 member states or even more member states said, we don't want to have a duty, even though there may be dumping and injury, because we don't think it's in the union interest. And the classic case on that is a big and old case, but it is a case on unbleached cotton fabrics where this happened. So the member states basically said to the Commission, we're very sorry, but we don't want anti-dumping measures on this product because it is an input product for so many users, for so many industries. Then the case kind of disappeared into the void, to use a term from the WTO. And later that was taken to the court by the European industry, which felt that they were unfairly treated because there was a dumping and there was injury, and they won on that issue. But because the decision-making process has changed since that time, you know, I think it has become relevant. I'm conscious of the time, so I think we have some other issues, but I turn the floor over to Philippe, with your permission, Renata.
I assume that I have your permission, Renata.
You do, you do.
Okay, okay. Good, thank you. Let's move now to maybe a bit of science fiction, namely the Commission's white paper on foreign subsidies. It's a very interesting subject because it's a mainly a mixture of competition law, trade law, state aid, and heavily influenced also by Brexit. What is the background? As we all know, the ASCM and the Basic Anti-Subsidy Regulation only deals with subsidies given to foreign companies for relating to goods, to the production and export of goods. We may have heard from Edwin that the notion of foreign companies may also cover companies outside the country of the subsidy granting government. But certainly it does not extend to subsidies given to services or subsidies given to companies within the EU. This was always a source of frustration for the European industry, because the European industry is obviously subject to state aid rules. Now, if a company in Europe receives money from a member state, this has to be cleared by the European Commission. And if it exceeds a certain threshold, obtaining actually this clearance by the European Commission is not an easy task. Now, these European companies saw their competitors receiving subsidies from foreign governments, and this fell outside the scope both of the basic anti-subsidy regulation, which only relates to goods, and only to subsidies to companies outside Europe, and it fell outside the state aid regime because it was given not by a member state. So this has been really a source of frustration. And I remember years ago being approached by European telecom producers complaining about Huawei, which is obviously the obvious company to complain about, that Huawei was actually getting a lot of contracts because they allegedly received subsidies from the Chinese government, and they could not receive support from their member states because that was a prohibited state aid. Now, what has the Commission done? They have now put forward a white paper on foreign subsidies, which would actually catch this kind of subsidies given by foreign governments. And I quote what is in the white paper given as a definition of the foreign subsidy. Namely, it would be a financial contribution given by a foreign government in the wide term, benefiting directly or indirectly an undertaking in the EU, offering goods or services or engaging in investments. So it would, under this proposal, so the foreign subsidy would cover foreign subsidies which are granted directly to companies established in the EU, foreign subsidies granted to a company established in a non-EU country, where such subsidy is used by a related party established in the EU. For instance, US gives a subsidy to one of its subsidiaries or one of its companies outside the EU, which again then transfers money to a company in the EU. That would be an idea of an indirect subsidization. And you can also have foreign subsidies granted to a company established in a third country where such a subsidy is used to facilitate the acquisition of an EU undertaking or participation in a public procurement procedure. So what we see is that it's a very wide scope. It would basically cover everything which is not yet covered by the basic anti-subsidy regulation and the ASCM, as far as the scope is concerned, and the condition would be that these kind of foreign subsidies cause distortions in the EU market. So the requirement would be that first you identify the existence of a foreign subsidy, and additionally you would require it would be required that this causes a distortion. And then if the investigation starts and they find indeed a distortion, there will also be some kind of public interest test. I know you like that. So the public interest test would then be maybe if the benefits for the EU economy of a foreign subsidy. Why would you complain if someone else wants to give you money? If this, the benefits of this foreign subsidy for the EU economy actually outweigh the negative effect of the distortion, then it could be cleared. So the white paper also proposes further that we have 3 different modules in which we would deal with the kind of foreign subsidy. The first module would actually be a kind of ex post scrutiny of foreign subsidies. So any company which has received a subsidy, and the minimum, the thresholds are very low, it's 200,000 euro over a 3-year period, that would be sufficient already to fall within the scope of this kind of ex post scrutiny. And this kind of subsidy is likely to create distortive effects in the European market, could be subject to this kind of scrutiny by the member states or the Commission. That has not yet been decided which role each party will play, the member states or the Commission. They have to decide on the thresholds which would be applicable. But for instance, examples of these subsidies which are likely to create distortions, and they are given in the white paper, and I just list a few of them: export buyer financing, debt forgiveness or guarantees, tax relief, and subsidies directly facilitating acquisitions. So these are presumed to have distortive effects. So it actually means that if you have made an acquisition in the past and the Commission or the member states examines whether this acquisition has been facilitated by a foreign subsidy, they can open an investigation. And if they find that the negative effects, the distortion, is not outweighed by the positive effects, they can actually adopt measures. And these measures, again, in the white paper, are a very wide list of possible measures. And I quote again, they can include the prohibition of the market conduct, divestment of assets, obligation to give access to R&D or licensing obligations, prohibition of investments or subsidized acquisitions, and even redressive payments. So it is really a kind of, this module 1 is a kind of catch-all whereby the member states or the Commission can look whether in the past you have obtained subsidies which have allowed you to get a kind of fair benefit in the EU market in order to acquire other companies, to enable market share, to get access to R&D or whatever. This is module 1. Module 2 is an ex ante review, so prior review of subsidized acquisitions. So this would be a situation whereby a company, a foreign company wants to, or a company within the EU but receiving foreign subsidies, wants to acquire another company in the EU. So there also, if you have received subsidies as the acquiring company, if you have received subsidies from a foreign government in the past, you must notify that to the Commission. Again, could also be the member state. To the schedule, the precise levels of competence and have not been decided, but there is this kind of prior notification obligation before you may continue with your acquisition. And there again, the Commission will analyze whether this is there a distortion in the acquisition process of the company as a result of this subsidy, and if so, is there a distortion which is not outweighed by the benefits for the European economy? And if they find there is a distortion which is not outweighed by the benefits it brings, the Commission can actually prohibit the acquisition of the company by another company which has received foreign subsidies. So this is an additional procedure which comes on top of the existing procedures already to scrutinize acquisitions. Because in competition law, obviously we have something like merger control, where the European Commission, DG Comp, can already carry out a review of an acquisition in order to see whether it would not result in negative effects on the competition in the European market. So here now we have an additional proceeding which stands separate from the merger clearance investigation. And in addition, obviously, we also have the foreign direct investment screening. So if you're a company which has received subsidies and you want to acquire a company in the European Union, you may be subject to 3 different investigations and 3 different procedures. I think obviously lawyers will like that, but it is certainly not good for companies, especially if you can actually have conflicting outcomes in the 3 different investigation, whereby you get your merger clearance, but because of the subsidy, your acquisition is not approved. And then finally, and that's the end, we have this 3rd module, which relates to government procurement. There also, if you participate in government procurement and you have received foreign subsidies in the past, you should notify that to the Commission, where they will then carry out an examination whether this kind of foreign subsidies you have received, and you are yourself under the obligation to notify, actually result in a distortion of the procurement process. If you refuse or you forget to notify, you may be excluded of government procurement, not only in that procedure, but also for future procedures. So this is a bit the new toolbox that the Commission is thinking about, and which obviously is very interesting because it sits across the competition rules, trade rules, foreign direct investment screening. And it is also very interesting because this time the obvious target is not only China, but could well be the UK. Because as we know, in the Brexit negotiations, there's a lot of talk about a level playing field. And one of the main issues here in creating a level playing field is the adoption by the UK of state aid rules, similar to the ones applied by the European Union. Because the last thing the EU wants is to be confronted with competition from the EU, made possible by subsidies by the UK government. So it is very well possible that if this tool comes into action, that it may be used not only against China, but also against UK companies. So this is in a nutshell. It's a very long document, but to get an initial flavor, I hope that this is sufficient.
Oh, excellent. This is very interesting. And I also thank you, Edwin, for the comment on union interest and public interest. So I'm concerned about the time. I'm sure all of us have another Zoom meeting in a few minutes. But I would like to ask you if we could extend for 10 minutes just to wrap up. Is it okay with the 4 of you, or? Yeah. So just to wrap up, I'd like, of course, to ask you, maybe I'll go first with Bonnie. I'd like to ask you if you can provide your perspectives on China trade relations, of course, focusing on trade remedies, state-owned enterprises, and maybe if Jesse could comment a little bit on what were the expectations with China when China acceded to the WTO, China expectations and the members' expectations, and what has China accomplished or not. Adding to that, of course, I'll open the floor to Philippe and Edwin to comment that if you want to react to each other's comments, feel free, so we can wrap up this session in 10 minutes. So Bonnie, if you'd like to go first.
Sure, thanks. You know, I've been giving this some thought. You know, obviously this administration has been very aggressive in their approach to trade relations with China. We had, as Jesse mentioned, the currency regulations, which really were adopted to deal with China. You've had the Section 301 cases, all kinds of duties imposed subject to 301. You've had Section 232. A very, very aggressive approach to trade with China. You know, it's unclear whether we're going to have another 4 years of this administration, but I really don't expect a big change when it comes to the anti-dumping and countervailing duty laws in the application of those laws to China, even in a Biden administration. The people that are advising the candidate have taken a position that we need to continue to have a strong U.S. policy vis-a-vis China. I don't know what will happen to the 301 tariffs. It could be that those get traded away for some additional concessions from China. But for sure, on the anti-dumping and countervailing duty side, I don't see a big change in methodologies with respect to how dumping is calculated. You know, I don't see a new administration conferring market economy status on China, for example. I just don't think that's going to happen. And one of the reasons for that is there hasn't been really any change in Chinese policy vis-a-vis becoming more market-oriented. If anything, we've seen since their accession to the WTO, probably some steps back in terms of, for example, government ownership of many corporations, and the role of state-owned enterprises in China has strengthened, if anything else. So I just don't see a big change in that, but I'd be interested to know what the others have to say about that.
Jesse? Mm-hmm.
Okay, I'll try and be very short here. The interesting thing that's happened here is that the whole expiry of the provisions about non-market economy status in the protocol, which was supposed to be sort of the big event of the decade, of the last decade, turned out to be sort of a non-event. So for many years, people have been preparing for the day when you couldn't use a non-market economy methodology against China. It looked like it was shaping up to be the sort of the biggest confrontation, you know, sort of a global scale confrontation. And instead, it's all sort of frittered away. And it seems that the Chinese were not being successful in their dispute against the European Union, and they basically dropped the whole thing. So ironically, we've had people experimenting with all kinds of different ways to address the issues in China. For example, the resurrection of countervail for non-market economies, and all kinds of ways that people were playing with countervail, and all the pushback we had on the countervail side. And then when we had all the pushback in the countervail side, including a variety of quite restrictive rulings in the WTO, then people decided, well, if we can't use the non-market economy methodology against China, we'll come up with all these sort of alternative MFN type approaches, and we'll use anti-dumping as a way to address government distortions instead of using countervail as a way to address government distortions. Now, it seems that we're never going to have a ruling that you can't use non-market economy methodologies against China. So we don't have an appellate body, and there are no cases that China is actively pursuing anymore. And yet this whole sort of Pandora's box, I would say, has been opened sort of globally with respect to what is anti-dumping all about. Is anti-dumping all about you know, pricing behavior of companies, or is anti-dumping really about government distortions of the market? And the implications of that Pandora's box are that to a certain extent, there's a fight going on about the soul of the anti-dumping agreement, and really what is it intended to achieve? And although these new methodologies, Philippe says, these new methodologies are being used for China, I think what we're seeing is these new methodologies, you don't make a new methodology available. It's going to be used by everybody, against everybody. So all of a sudden, we have an anti-dumping agreement that's maybe all about distortions instead of being all about, you know, price discrimination, sales below cost. And that's going to be a very interesting development to watch. So that's what I'll say.
Excellent, thank you. Edwin, would you like to go next? You're muted.
As Philippe already said, also China is now considered a systemic rival. Personally, I think it's unfortunate because living in Europe and having lived in Europe for a long time, I don't think it's a situation of black and white. Europe is full of subsidies, even before COVID. So, you know, this idea that in China everybody gets subsidized and that we in Europe have clean hands because we don't subsidize, I think it's an idée fixe that doesn't exist in practice. So I think these kind of terms of this terminology, systemic rival or competitor, it is more done for public relations purposes and to set a certain anti-Chinese atmosphere than that the systems as such in Europe and in China. And I think that in the United States, it may be quite different, but Europe and China are not that far apart in many of the kind of practices that the EU accuses China of. I think I'll leave it at that. I'm very conscious of the time, and I do have another meeting.
So Philippe, I'll leave with you to conclude our session.
Maybe two comments. First on what Edwin said about Europe and China. I remember representing China in the fasteners case, in EU fasteners, where there was the notion of what is a non-market economy and the application of the ad note to Article 6. And there indeed, when we looked at the figures, it seems that the share of the government of the economy in the overall economy in certain European countries like France was very similar to what we found in China. I'm not saying that may have changed in the last years, but indeed, if you look at the share of government in economic activity in Europe, we are obviously much closer to China than we are probably to the VS. I think more importantly for the future, and I fully agree with Jesse, we will see an erosion of the traditional concept of what is dumping and what is anti-dumping measures and how we will react against allegedly dumped imports. I think we will come to a bigger notion, as Jesse said, of what are distorted imports. And distortions may be completely different or much wider than the distortions we address now or historically in the anti-dumping agreement. So we have seen, for instance, in the modernization package of the European anti-dumping rules, the introduction of the concept of social and environmental distortions. That you could say that one country is able to export to Europe at cheaper prices because they don't respect environmental standards, while the European companies have these emission trading systems and have to pay for that, have environmental costs. You may have situations where people are able to export cheaply because they don't respect, for instance, minimum wages or do not have the ILO. You may have market distortions resulting from the non-application of competition rules. So what we may see in the future is that in anti-dumping, we may extend the notion of distorted economies to cover not only prices and costs distortions and input level, but also wider societal distortions, such as environment, such as social rights, such as competition rules. And once this is opened, as Jesse also pointed out, it will no longer be China alone. You could, and in Europe, people already say we should be able to take measures against the US because they are not signatories to the Paris Convention. So we have to be very attentive about what is going to happen in the future. So I don't want to sound like a Cassandra, but this is the last thing I wanted to say. Okay, thank you.
Thank you very, very much. There is one question for Bonnie, but I would like to ask Bonnie if I can maybe forward this to you through email later. And thank you. So thank you very, very much. I know you're very busy people, so thank you for taking the time to talk to our students and to Brazilian government. And I know there are a lot of people from Europe and the US also connected. I would like to thank everyone that joined us. We will make this recording available in our YouTube channel, so I'll send it to all of you. Thank you very, very much, Jesse, Philippe, Edwin, and Bonnie. This was excellent. And I hope we have other opportunities to discuss in deep everything you said, because I think we could have one session for each round of questions we prepared for you. So thank you so much. Thank you all.